All right, I think we can get started. I still see some folks rolling in, but we have a little bit of an intro that will give an overview before we get into the substance. So people will have a chance to catch up to us. So welcome to our Supreme Court's report webinar. Thanks so much, everyone, for joining us today. We know it's a busy time with a lot going on, so hopefully our conversation this afternoon can help bring a little bit of clarity to at least some of the chaos. My name is Jenna Ruddick. I'm a policy counsel here at Free Press, and I'm joined by Yanni Chen, who is also a policy counsel here at Free Press. For those of you who already regularly follow and support our work, Free Press is a media and tech advocacy organization championing communities' rights to connect and communicate. So this Supreme Court season, we've been watching 5 cases with particular relevance to that ongoing work. We have one standalone case, Murphy v. Missouri, and 2 pairs of cases, the shorthand for those being the Chevron cases and the net choice cases, and that's what we'll be talking about today. Only the Murphy case has had a decision released by the court so far, so we'll go over the Murphy decision and then move on to the other cases. But before any of that, I'm going to turn it over to Yanni to help orient us to the Supreme Court's process here and where we are in it. I'll just add 2 quick logistical notes at the top. I think we're aiming for around 30 minutes, but we'll leave plenty of time for question and answer at the end. But also, please feel free to send questions at any time, and we may answer them if we catch them, but if not, we'll come back to them. So I'll kick it over now to Yanni to get us started.
Hey everyone. So I think we're just going to start quickly by explaining the life cycle of a case at the court. It's helpful just to situate us and also give some transparency to something that seems a little, it seems like there's no method to the madness sometimes from the outside. So essentially, a term begins on the first Monday of every October, and it'll run typically through the end of June, after which the court will recess. And so the life cycle of a case will typically go something like this. So first, there's something called the cert stage. And with that, a court will decide whether to grant cert on a case. And cert essentially means that they will agree to review it and hear oral argument. And so unlike federal circuit courts, which have to take every case that gets appealed to them, the court gets to actually pick what they want to review. And parties will argue why or why not their appeals should be heard. And so thousands of cert petitions are filed each term, and about 100-ish or sometimes more are granted. And so then you move on to the merit stage. So first briefing takes place. And so the parties will file briefs explaining their case on the substance, as opposed to in the cert stage where they're just explaining why the court should hear it. And then an oral argument is heard. And so oral argument is from October to April of each term. And so any case granted cert until about January of a term is argued in that same term. And then anything granted after that in the term is typically argued in the next term. And so then after a given oral argument, the judges will conference with each other, and they'll go in turns by seniority, and they'll explain their position on a case, and then they'll vote on their position in that same order. And then they will decide who will write an opinion. Typically, the most senior justice in the majority will assign who will write that. And so then once a decision is written, the justices will circulate and decide to sign on to opinions. And concurrences and dissents might also be written at this time. So you'll see throughout this consideration process, there's a lot of play in the joints to coordinate with other justices. And there's some compromise also that's happening. And so different justices have different approaches to this. Some might seek compromise and they value speaking with the whole voice of a court if they can get that, but maybe compromise on a few policy positions. And then some may take more of like a scorched earth approach and really stick to their own convictions. And so there aren't any term or any kind of rules about how early in a term a decision can come out. A decision for a case argued in October can come out in November, as early as November, but typically the bulk of them are released after oral argument ends in April. So towards the end of June, they will start coming out in a more frequent fashion. So by tomorrow, ostensibly, they should all be out, but that probably won't happen. And sometimes it'll extend to early July, which is happening now. We don't really know like the order in which cases come out or when cases will come out. You'll know what days opinions are coming out, but not specific cases. You can maybe try and read tea leaves a bit, but it's not really a science. And so right now there's about 8 cases left, depending on if you count, the Chevron cases as one or the net choice cases as one. And we know that tomorrow will not be the last day of cases because the marshal didn't say that today when the opinions are being read. And Monday is also listed on the court calendar. And this has happened before as well. So with that kind of framing in mind, I'll kick it back to Jenna.
So like I mentioned at the top, we're going to talk about 5 cases today. 2 of them are sets of cases that we're still waiting on decisions from the court. And one of them is Murthy v. Missouri, which we got an opinion in yesterday. So Murthy v. Missouri is a case that involves a group of plaintiffs. There were 5 individual social media users and 2 states, one of which you might have already guessed was Missouri. That claim that a variety of federal officials and agencies, including the White House and CDC, had engaged in censorship through their communications with social media platform companies about content on a variety of topics, including election integrity, the 2020 election results, COVID, and other public health information. So the plaintiff's claim was that these agencies and officials violated the First Amendment by coercing the platforms to remove speech that otherwise wouldn't have been removed. Procedurally, the lower courts sided with the plaintiffs, and the result coming into the Supreme Court was that there was a pretty sweeping injunction in place against communications between platform companies and government officials. So yesterday, Wednesday, in a 6-3 decision authored by Justice Barrett, the Supreme Court held that the plaintiffs in the case hadn't established what's known as Article 3 standing to seek an injunction against any of the defendants. So the court didn't actually end up reaching the First Amendment questions in the case. Instead, the court found that the plaintiffs had failed to demonstrate that they had suffered or likely would suffer harm as a result of the federal government's communications with these social media platforms. The court also ruled that the alleged harms in the case wouldn't be solved by the injunction or court order that was being sought by the plaintiffs. So in the opinion itself, which is the only opinion we have to actually walk through a little bit today, the court noted that the plaintiffs had failed to demonstrate that it was the government's communications with the platforms that had caused the platforms to take down specific pieces of content, rather than the platforms themselves independently responding to violations of their own content policies or terms of service. So the opinion actually walks through specific examples of pieces of content that were raised in the case and the surrounding evidence. So for folks who are interested, I'd really recommend taking a look at that. It's very interesting. One example the court cited on the question of COVID misinformation, for example, was that Facebook had announced its expansion of its own COVID misinfo policies before the White House began communicating with the platform, and that even after they began communicating on several occasions, White House officials had flagged content that didn't violate company policies, and so it wasn't removed. The court also noted that the platform companies didn't only communicate with the government defendants in this case about topics like moderating COVID and election integrity content. The platforms also regularly spoke with other outside experts and researchers. So we were really glad to see this outcome. Even though the court didn't address the First Amendment issues here, it did recognize that platforms are free to make their own content moderation decisions, and that there was insufficient evidence to suggest that the platform's communications with government officials with expertise in areas like public health or election integrity had played a coercive role in the platforms choosing to remove certain content that violated their own policies. And also external researchers and experts have been a critical resource when it comes to content moderation on various social platforms around critical types of content. So it was really encouraging to see that recognized in this decision. I think I'll pause there. Feel free to pop any additional questions in the chat. But in the meantime, I'm going to kick it over to Yanni to dive into our first pair of cases.
Yeah, and I just saw a question in the Q&A about the shadow docket, so I'll just address that really quick. So yeah, I was just talking about kind of the typical merits cycle of a case, but there is also something called the shadow docket, which is basically an expedited, there's usually no hearing or there's very quick briefing. It's as kind of a separate bucket where there's usually some sort of time crunch. So that can be usually seen in like the injunction, or where basically a lower court has granted an injunction or a stay and someone's seeking quick relief and they can't really fit into that schedule I outlined. Some justices really don't like it. Justice Kagan is one of them. I think that some people view it as like an obstruction of the process that's being put out. And as someone who has filed during a shadow docket case, it's pretty rough. So it's definitely a separate process. But as you might know, the net choice cases also were on the shadow docket when the preliminary injunctions went down. So that's where you might see it. And obviously there's also things like stays of execution and the death penalty that the court covers as well, that those get kind of handled outside of that kind of schedule I had mentioned. But onto the Loper Bright case and the relentless case, I'll try and speed through the facts a little bit just because they are not as relevant, I think, for the conversations that we are having today, but they'll be helpful to understand kind of the issues. So basically, there's an agency called the National Marine Fishery Service, and they put out a rule requiring Atlantic herring fisheries to carry observers on their fishing trips. And that's just to collect data for conservation efforts and, management efforts. And they did this under the authority of an act called the Magnuson-Stevens Act. And under this arrangement, the boat owners need to front the cost for the third-party observers. So in Loper Bright, a group of fishers, and in Relentless, a group of owners of fishing vessels challenged this rule. And they're basically arguing that the Magnuson-Stevens Act doesn't give the agency authority to collect these fees. And the government argued that the agency's interpretation of the Magnuson-Stevens Act and that they can collect these fees is a reasonable thing. And so basically what this case is about is something called the Chevron Doctrine, which is a doctrine that was formed in 1984 that essentially says that a court needs to defer to an agency's reasonable interpretation of an ambiguous statute when they are reviewing agency action. And so that's a mouthful. So I'll explain kind of the rationale for why this rule exists. And so essentially, this rule exists to set ground rules for the different roles played by different government actors. So agencies, Congress, and the courts. And so Congress typically gives agencies the authority for expert groups to make policy. And under the theory that lawmakers are typically generalists and they want to leave the specifics of regulating specific areas to the experts in that area. And that's important because that means that rules can be tied better to the realities of the industries and the fields they're regulating. Agencies can also move quicker and to reflect changes in circumstances in industry. And then also in a time like now where there's a lot of gridlock in Congress, this is how a lot of effective policy gets done. So we would love a net neutrality law, for instance, but politically that's less feasible and it would take a long time for that to be able to come about. So the issue in this court, or in this case, is whether to overrule Chevron or whether there's a certain situation in which Chevron could be limited. And in this case, that's about whether a statute is silent and whether that's considered an ambiguity that affords the agency deference. And so at oral argument and kind of in general, the justices fall along kind of partisan lines on this issue. So the liberal justices tend to view Chevron favorably. There is a mass body of cases that rely on Chevron, and they emphasized a lot on the importance of stare decisis, which is kind of following the cases and the precedent that exists before it. And the conservative justices tend to be concerned about the policy swings that happen among administrations, and some of them have really been concerned about, the power of agency action since even before they were justices. So that's someone like Justice Gorsuch. And so based on kind of the breakdown of the court and their likely dispositions, I think there are two likely outcomes. One is a total overturning of Chevron, and under that, you would revert to something called Skidmore deference, where agencies' interpretations of statutes are just a factor for courts to consider when they interpret statutes, or they could weaken. My lights just turned off. I'm sorry. Or they could weaken Chevron and just clarify the limits of when it applies. And they've done that before with different types of agency deference, like something called hour deference. And so I think the reason why it's important is that it really kind of impacts the FCC and some of the agencies that we care about. So the FCC's ability to regulate would definitely be compromised if Chevron were to be overturned. The FCC deals with a lot of specialized and technical matters, and we want them to be able to make rules that accurately reflect the technology they deal with. I think one really salient way this could come about soon is in the net neutrality litigation. So as some of you may know, in this year, the FCC just put out a order reinstating net neutrality litigations and Title II classification of broadband internet. And now it's being challenged in court. And there is a really helpful seminal case called Brand X that helps the FCC kind of back up what it did. And Brand X holds that Chevron deference applies when the FCC makes a regulatory classification decision, like when broadband falls under Title II or Title I. That's not to say we can't win net neutrality litigation without Chevron. The FCC's order does a great job advocating that Title II is the correct classification, independent of necessarily its recommendation, but it does make it harder to kind of make this case. And then it's also really important when we consider the administrative state more broadly. So agencies do a lot of important work in a lot of different spaces. That includes reproductive justice, environmental justice, and workers' rights. And so for the reasons above, it's really important that agencies are given the latitude to kind of make the decisions that they need to make. So with that, if there's any questions, I can answer them. Or I can also just wait for, or you can kick it over to Jenna.
Because there are still more cases, even though tomorrow was supposed to be the last day. Like Yenny said, we're still waiting for a lot to come out of the court. The Chevron cases are two of them, and the net choice cases are another pair, and the final ones that we'll be covering in this webinar. So again, this is another pair of cases with similar issues and similar facts, although certainly not identical. The first case is Moody v. Net Choice, and the second is Net Choice v. Paxton. Ken Paxton is the Attorney General of Texas. Ashley Moody is the Attorney General of Florida. So these cases involve laws that Texas and Florida separately passed to regulate social media platforms' content moderation decisions. So the laws themselves also aren't identical, but share some core features, including restrictions on what types of content the platforms are legally allowed to remove, effectively requiring platforms to host content that might otherwise go against their existing policies. So both of these cases, like Murthy, raise First Amendment questions, although also like Murthy, that doesn't necessarily mean that the court will reach the constitutional issues here. The key First Amendment question in these cases involves the platform's rights to exercise editorial judgment. So in other words, does Facebook or TikTok have the right to take down posts or videos that violate platform policies? The states are claiming that these decisions amount to censorship, hence passing the laws that they've passed. But there's a lot of First Amendment precedent to address the exercise of editorial discretion. So the current state of this on the internet is that websites, including the big social media platforms, much like other publishers, are largely allowed to create and enforce their own policies on what they will and will not host. On our team at Free Press, we've raised a lot of concerns about how these companies create those policies and how they do or don't enforce them, including policies on hate speech and election disinformation. But I'm going to actually quote my colleague Nora Benavides here, who wrote earlier in the spring following the oral arguments in these cases, that regulation, like these states' regulations, that places the control of private companies' content moderation decisions in the hands of state officials, really does run afoul of the First Amendment, and both risks forcing platforms to leave violative content up, while also offering a convenient excuse for inaction by platforms that already have a track record of negligence in leaving up harmful content, such as harmful content, incorrect information around election integrity, as well as hate speech and harassment. So again, we're still waiting to see what the court will say. And again, like in Murthy, we could see decisions here that avoid the core constitutional questions. During oral arguments, a number of the justices expressed frustration that there wasn't a well-developed record from them to go off of from the lower courts regarding how these laws would work in practice, to the point of justices asking questions even about how these laws might apply to e-commerce platforms like Etsy, or kind of platforms that aren't the large social media Metas and Googles that are more clearly front of mind in these cases. So we'll see in the next few days where they landed. It's not clear where they'll go, but it'll be very interesting no matter what. They have pretty significant implications for how social media platforms can or cannot moderate all sorts of content on their platforms, which, coming up into the kind of peak of the election cycle, is of particular relevance. So let's see. If we have any more questions, please feel free to drop them in. I think Danny, our lovely moderator on the back end, mentioned that we'll be answering stuff through the Q&A feature versus raised hands or any function like that. Let's see. We may be in the clear on questions. I'll give it another couple of minutes. So we're closing in on the top of the hour anyway. All right, we've got a couple coming in now. So this is a great question relating to the net choice cases. How can people be aware of misinformation on social media if the court rules in favor of social media platforms versus government regulation? So I think that'll be kind of a live question. If the court kind of goes in the direction of supporting Texas and Florida's laws, then we're in a place where the companies will have to leave up content, and there will be questions around how they can use other types of signaling messages like flagging content. We see things on Twitter now, X, like community notes, other features that distinguish or might reduce the availability of content, even content that's not removed. I think also the role of researchers and journalists will become very important to educate people around what we're seeing on platforms, what types of misinformation and disinformation campaigns we might be seeing, so that people can be aware themselves. Because if the companies, which already have a track record of struggling sometimes to address mis and disinformation on their platforms, are required to keep that content up, then we're going to have a situation where the burden is really on users to track and be aware of and to educate one another. So we'll see how that ends up playing out. And I think we have a similar related question about how to bring the general public up to speed about key issues. Hopefully this webinar and other tools like it help play a role, but also I think everyone in the audience is in a position to help play a role. This is something that you can talk about with colleagues, with friends, with family. I think people are really invested in a lot of these cases and what the implications of these cases are, even though kind of the legal in the weeds piece might feel pretty daunting. There are implications for all of us, and there's no reason that the general public shouldn't be involved in these conversations. Yenny, I'm not sure if you have any thoughts on that one.
No, I think that's right. I think that's unfortunately the main and most effective thing to do. I think that sometimes we want to have like a direct process, but I think just persistence here is important. I'm also seeing another question on speculating about the immunity case. I personally have no idea. And that's not the most helpful or educated kind of statement. But yeah, I think it's just into someone else's kind of question comment about how abnormal these times are. It's just anyone's guess. I think, yeah, there's a lot going on at SCOTUS that is unprecedented, both, you know, in the opinions themselves and the things we're seeing outside of the court that are happening with the justices.
And we have one other question about the issue of censorship more broadly and what's being done to protect us from censorship. First and foremost, that's the role that the First Amendment is meant to play. It's meant to address the issue of government censorship and government control of what information we both communicate and receive. So that is kind of the core of protections for us here in the United States. And I would say it's a pretty robust one. And then somebody else has asked for more talking points to help people who aren't necessarily following the news. We're going to send out the recording from this webinar to everyone who registered. We can also include blog posts and writing that we've done on these cases that I think also help lay this out on paper. And we'll also be keeping you in the loop for folks who are signed up for our emails. We'll be keeping updates kind of regularly through those. And we are officially at the top of the hour. So Yenny, if you have any closing thoughts, I'd kick it over to you. Otherwise, I'm happy to wrap us up.
No, nothing for me. Thank you all for listening.
Same here. Thanks so much, everyone. Again, we'll be sending out the recording, so keep an eye for that and other resources that we'll be sending out through our mailing lists. And happy SCOTUS Watch tomorrow. Tune in at 10 a.m. to see what cases are decided and find out how many we'll be looking for next week. Have a good weekend, everyone.